Thank you for joining us for another episode of our Notebook Deep Dive podcast. These podcasts are based on either books, essays, or lectures I have written or given over the last 3 decades.
All right, so today we're going to be taking a deep dive into plea bargains.
Oh, yeah.
You sent over a ton of legal documents on this, and I gotta say, it is fascinating stuff.
Yeah.
90% of criminal cases actually end in plea bargains.
It's true.
It's crazy. It's like the hidden backbone of the entire justice system.
Yeah, that's right.
So our mission in this deep dive, I guess you could say, is to try to give you a clear understanding of how plea bargains work,
Okay.
how they affect defendants, and how they impact our concept of justice itself.
Right.
So get ready for a little bit of a journey through the legal maze here.
Sure.
But don't worry, we're going to translate all the jargon.
Okay.
We'll highlight the most intriguing parts.
Sounds good.
So first things first, what exactly is a plea bargain?
Well, at its core, it's really a contract.
Oh, a contract.
Yeah, an agreement between the state represented by the prosecutor
Okay.
and the defendant.
So where does the judge fit into all of this? Are they like the referee in this legal contract negotiation?
The court isn't a party to the agreement itself,
Okay.
but the judge plays a crucial role. They ensure the process is fair,
Gotcha.
that the defendant understands the agreement,
Right.
that there's no coercion involved,
Yeah,
that they're there to protect the defendant's rights.
that makes sense. I was reading about this concept called a cold plea, though.
Right.
What happens in those situations?
A cold plea is when a defendant pleads guilty without any kind of deal with the prosecution.
Oh, wow.
So it's essentially surrendering to the charges.
Oh, so they just give up.
It can have some serious implications for the defendant's sentence.
Yeah, because they're at the mercy of the court at that point.
That's right.
Wow, that's a high-stakes gamble.
Yeah.
Why are plea bargains so common in the first place? Is it just about everyone wanting to avoid a drawn-out courtroom drama?
I mean, I think for some people, that might play a role.
Sure.
The reality is much more complex. I think
Yeah.
the sheer volume of criminal cases puts immense strain on the justice system.
Excellent.
So plea bargains help to manage this workload by expediting the process.
So it's really about keeping the wheels of justice turning?
Exactly.
Does this mean the focus on efficiency could overshadow a defendant's right to a fair trial, though?
That's a great question.
Yeah.
And it's one we need to grapple with, I think.
Oh, sure.
While plea bargains can be beneficial in some cases,
Uh-huh.
we have to consider the potential for coercion,
Yeah.
especially for those who may be innocent but feel pressured to accept a deal.
Yeah, that raises a lot of concerns about whether plea bargains can truly be fair to defendants.
Right.
Are there specific instances where this pressure might be more pronounced?
One example is vindictive sentencing.
Okay.
So that's a concern when a defendant chooses to exercise their right to a trial
Right.
and is then given a harsher sentence than they might have received through a plea bargain.
So they're being penalized for going to trial.
Right. It raises the question of whether the defendant is being punished for asserting their right to a trial.
It sounds like a delicate balancing act.
It-
Can we break down what a plea bargain actually looks like in practice?
Sure.
What are the different forms they can take?
So plea bargains can involve a range of outcomes.
Yeah.
Sometimes it's about dismissing certain charges entirely.
Oh, okay.
In other cases, it might involve reducing the severity of the charges
Gotcha.
or having the prosecutor recommend leniency in sentencing.
I was looking at a hypothetical case in these documents.
Okay.
Imagine someone charged with armed robbery,
Yeah.
kidnapping, a feed, a firearms violation.
Wow.
That's a lot to deal with.
Yeah.
How might a plea bargain play out in that situation?
In a case like that, the defense might argue for the dismissal of the firearms violation,
Okay.
especially if the defendant is a minor.
Interesting.
The prosecution might agree to drop that charge in exchange for a guilty plea on the robbery and kidnapping charges.
So it becomes this strategic negotiation.
Exactly.
Each side has to weigh their options and assess their leverage.
Right.
What factors might influence these negotiations?
The strength of the evidence is crucial, of course.
Makes sense.
The defendant's criminal history also carries weight.
Mm-hmm.
And, of course, the potential consequences of a conviction play a huge role.
Right.
So each side tries to assess what they could gain or lose by going to trial.
That makes sense. You're weighing potential risks against potential rewards.
Yeah.
But with such high stakes, how do we ensure these negotiations are fair?
Right.
And that someone isn't being pressured into taking a deal that's not in their best interest?
Well, there are legal safeguards designed to protect the defendant's rights during this process.
Okay, like what?
One crucial safeguard is the Boykin colloquy.
I've heard that term before.
Right.
But could you explain it in simple terms?
Yeah.
What exactly is a Boykin colloquy?
Essentially, it's a process where the judge directly questions the defendant
Okay,
to confirm they understand the plea agreement
gotcha.
and the rights they're giving up by accepting it.
So it's like the judge hitting the pause button
Yeah.
and saying, hold on, let's make sure you fully grasp what you're agreeing to here. That sounds incredibly important,
It is.
especially given the pressure that might exist in these situations.
It's where clear documentation also becomes crucial.
Oh, okay.
Everything needs to be clearly spelled out in the plea agreement,
Right.
from the specific charges being dropped or reduced
Mm-hmm.
to the potential sentencing range.
So it's like a paper trail,
Right.
ensuring everything is done by the book.
Exactly.
What if someone pleads guilty
Right.
and later discovers they weren't fully informed about something critical,
Yeah.
like a mandatory minimum sentence? Could that affect the plea agreement?
You've hit on a very important point. There have been cases where a defendant was not properly informed about the full consequences of their plea,
Oh, wow.
including things like mandatory minimum sentences.
And so they get out of the plea deal.
Yeah. And that lack of information has been grounds for overturning the plea.
That's a powerful example of why these Boykin colloquies are so important.
It is.
They're not just a formality. They're there to protect defendants from making uninformed decisions
Exactly.
with lasting consequences.
Yeah.
It seems like this process is designed to balance the need for efficiency with the need to ensure fairness.
You got it.
What other safeguards are in place to protect defendants during plea bargaining?
Yeah, the Boykin colloquy is definitely a cornerstone of fairness in plea bargains,
Okay.
but it's not the only safeguard.
Hmm.
For instance, any waivers of rights,
Yeah.
like the right to a trial,
Right.
must be made knowingly, intelligently,
Knowingly, intelligently.
involuntarily.
Okay. I'm going to need you to break that down for me a bit.
Sure.
Those are some pretty weighty legal terms.
Right.
What do they actually mean in practice?
Yeah. Good point. It can definitely sound like legal jargon.
Yeah.
In essence, the defendant needs to understand what rights they're giving up
Okay.
by accepting the plea bargain,
Gotcha.
and they cannot be pressured or coerced
Right.
into making that decision.
So it's about ensuring the defendant is making a genuine choice, not one made out of fear or desperation.
Yeah.
What about the prosecutor's role in this? Are there any rules governing their conduct during plea bargaining?
Absolutely. There's this principle against prosecutorial vindictiveness.
Okay.
This means the prosecution cannot punish a defendant for choosing to go to trial
Right.
instead of accepting a plea bargain.
So there's no retaliation.
Right. The sentence should be based on the facts of the case and the law,
Right.
not on whether the defendant exercised their right to a trial.
That makes sense.
Nah.
It wouldn't be fair to penalize someone
Right.
for exercising their constitutional rights.
Exactly.
But how do we ensure these rules are actually being followed?
Right.
It's one thing to have guidelines,
Yeah.
but another to make sure they're being implemented in real-world situations.
Absolutely. That's where transparency and accountability come into play.
Okay.
Meticulous documentation of every step in the plea bargain process is essential.
It's like a paper trail
Exactly.
to ensure everything is done by the book. What kind of information is included in this documentation?
Everything.
Okay.
It includes the specific charges being dropped or reduced,
Uh-huh.
the potential sentencing range,
Okay.
and a record of the discussions between the prosecution and the defense.
It sounds like this documentation creates a record,
Right.
almost like a safety net, to make sure everyone's on the same page
Exactly.
and that the agreement was reached fairly.
You got it.
But what if someone pleads guilty
Right.
and later discovers they were misled or coerced into taking a plea deal?
Okay.
What recourse does the defendant have if they feel their rights were violated during plea bargaining?
They can attempt to withdraw their plea.
Oh, they can.
Yes. But, as we discussed earlier, they need to demonstrate a fair and just reason for doing so.
So simply having second thoughts isn't enough.
Right.
What would constitute a fair and just reason in this context?
It could involve issues like ineffective assistance of counsel, meaning their lawyer didn't adequately represent them.
Gotcha.
It could also involve coercion or a fundamental misunderstanding
Right.
of the terms of the agreement.
So if the court agrees there was a problem,
Yeah.
the plea could be withdrawn.
Yes. The court has the authority to allow the defendant to withdraw their plea
Okay.
and proceed to trial.
Gotcha.
In some instances, there might even be grounds for an appeal.
It's clear that plea bargains involve a complex interplay of legal principles
Yeah.
and practical considerations.
It is.
Both the prosecution and the defense have a responsibility to navigate this process ethically
Right.
and ensure that justice is served.
I agree.
So you're saying both sides need competent legal counsel
Absolutely.
who understand the complexities of the law
Right.
and the ethical implications of plea bargaining.
You got to it's about striking that balance between the interests of justice,
Yeah.
efficiency, and individual rights.
That balance seems incredibly delicate,
It is.
especially given the potential consequences for the defendant.
It is.
What happens if someone pleads guilty?
And later discovers their attorney provided ineffective counsel during the plea bargaining process.
Okay.
What recourse do they have?
If a defendant believes they received ineffective assistance of counsel during plea bargaining, they can potentially challenge their conviction.
Okay.
They would need to demonstrate that their attorney's performance fell below a reasonable standard
Uh-huh.
and that this deficiency prejudiced the outcome of their case.
So it's not just about proving their lawyer made a mistake.
Right.
It's about showing that that mistake impacted their decision to accept the plea.
Exactly.
It seems like a high bar to clear.
It can be challenging,
Yeah.
but it's a really important safeguard.
Right.
We need to ensure that defendants have access to competent legal representation throughout the entire process,
Of course.
especially during plea bargaining where so much is at stake.
We've been talking about all the mechanics of plea bargains,
Yeah.
exploring the safeguards that are in place.
Right.
But plea bargains have become so ingrained in the criminal justice system.
They really have. That it's hard to imagine how it would even function without them.
It's true.
Is this reliance on plea bargains ultimately a good thing or a bad thing?
Well, that's the million-dollar question, isn't it?
Yeah.
There are very compelling arguments on both sides.
Let's play devil's advocate for a moment.
Okay.
What are some of the potential downsides of this heavy reliance on plea deals?
One concern is that it could undermine public trust in the justice system.
How so?
Well, if people believe that justice is being negotiated behind closed doors
Right.
instead of being determined through a fair and open trial,
Yeah.
it can erode confidence in the system's legitimacy.
So it starts to feel less about truth and more about striking deals.
Exactly.
What other concerns are there?
There's the worry that innocent people might feel pressured to plead guilty,
Oh, well.
even if they have a strong defense,
Yeah.
simply to avoid the risks and uncertainties of a trial.
That's scary.
They might feel like they just have no other choice.
Could factors like the experience of the attorneys involved
Huh?
or even implicit biases influence the outcomes?
Absolutely. Those factors can significantly impact the dynamics of the negotiation process.
So it's not just about the facts of the case.
Right.
It's about the power dynamics at play during these negotiations.
Exactly. Unequal access to resources.
Yeah.
The skill of the attorneys and even unconscious biases
Right.
can all contribute to disparities in plea bargain outcomes.
But on the flip side, what are the arguments in favor of relying on plea bargains?
Sure.
Why do some people see them as a necessary part of the system?
Proponents argue that plea bargains are essential for managing the immense caseloads
Yeah.
that our courts face.
The courts would be so backed up.
Exactly. Without them, courts would be overwhelmed, trials would be endlessly delayed,
Right.
and the costs would be astronomical.
See, it's really a matter of practicality,
It is.
of keeping the system afloat.
Yeah.
Are there any other arguments that support plea bargains?
Supporters also highlight that plea bargains can benefit both the prosecution and the defense.
Okay.
For the prosecution, it offers a guaranteed conviction without the expense and uncertainty of a trial.
Makes sense.
And for defendants, it can mean reduced charges, lighter sentences,
Right.
and a faster resolution to their case.
So it's like everyone kind of gives a little to get a little.
Right, a system of compromises.
But is this compromise always in the best interest of justice?
That's the question that we need to keep asking.
Yeah.
While plea bargains have become an integral part of our legal system,
Right.
we can't shy away from examining their impact and considering potential reforms.
Plea bargains are a powerful tool
They are.
that requires careful and ethical use.
Absolutely.
We need to be aware of the potential pitfalls
For sure.
and strive for a system that balances efficiency with fairness
Exactly.
and protects the rights of all parties involved.
I agree.
What would you say is the most crucial point for our listeners to remember as they navigate this complex landscape?
The key is to understand that plea bargains are not a simple shortcut to justice. They involve complex legal and ethical considerations that demand careful scrutiny.
So you're saying if you're facing criminal charges,
Yeah.
Having competent legal counsel is paramount.
Absolutely.
Your attorney can help you understand your options,
Right.
navigate the intricacies of plea bargaining,
Mhm.
and protect your rights throughout the process.
Exactly.
This has really highlighted the need for informed decision-making in the criminal justice system.
Yeah.
Before we wrap up, is there anything else you would like to add for our listeners?
I would encourage everyone to stay informed about the ongoing discussions surrounding plea bargains.
Okay.
Research the arguments for and against them.
Right.
Read about cases where plea agreements have been challenged.
Yeah.
Engaging in this dialogue is crucial to ensure our justice system is both efficient and equitable.
That's great advice.
Thanks.
Thank you so much for joining us today and shedding light on this complex and fascinating topic.
It was my pleasure.
And to our listeners, keep those brains engaged. And remember, knowledge is power, especially when navigating the legal system.
Please visit my Amazon author page and learn more on the topics of law, hypnotism, and self-improvement.